everyone, and welcome back to Lexy Talks Law. I am your host, Alexlarry Filani. Today's topic, a crucial aspect of family law in Nigeria, which is grounds for divorce. I repeat, today we are looking at grounds for divorce. We will demystify what it takes to legally end a marriage under the Nigerian law. And we also need to understand that to end a marriage under the Nigerian law, there are certain laws that governs these particular marriages. What do I mean is that there are different types of marriages on Nigeria. Nigeria recognizes different forms of marriages. We have the statutory Christian marriages, which is our main focus for today. And we also have the Islamic marriage. We also have the customary marriage. I will not bore you with the remaining two, but in order for you not to fall victim of thinking that you actually married under the act, and then later in life you discover that you actually married under customary law, let me explain. When you get married in church, when you get married in a church that is not a licensed place of worship to carry out marriage celebration, the marriage that you celebrated would fall back under customary law. That is, it will not be recognized under the act. So you need to understand this very, very importantly. So when you married at the court registry or in any registry that is licensed or any church that is like, this is the type of marriage that we are talking about. And so each has its own rules for dissolution, but today we are diving deep into statutory marriage and what it entails, the laws that governs it, and the likes. So, under the Matrimonial Causes Act, there's just one ground for dissolution, and that particular ground is what we are going to talk about today. The MCA under Section 15 of Matrimonial Causes Act talks about when marriages has broken down irretrievably. Marriage has broken down irretrievably. It's the only ground for dissolution of marriage. But there are different elements that amount to marriage breaking down irretrievably. The question is, what does irretrievably broken down means? It means that the marriage is beyond repair, or parties are irreconcilable. They can just not live together. That you need to understand that is the meaning of marriage has broken down irretrievably under Section 15 sub 1 of the Matrimonial Causes Act. And you also need to understand that the Matrimonial Causes Act is the only law that governs marriage. I mean the dissolution of marriage in Nigeria. So how do you then prove Section 15 sub 1 that your marriage has broken down irretrievably? Under Section 15 sub 2 of the Matrimonial Causes Act, we have enumerated lists of facts that you can use to convince the court that indeed your marriage has broken down irretrievably. You need to understand that. So one of these things, there are eight facts that I would like to enumerate that can support your ground that your marriage has broken down irretrievably. These facts are not ground in itself. They are evidences of the breakdown of the marriage. That I need you to know. Number one is willful and persistent refusal to consummate the marriage. What do I mean? Maybe one spouse deliberately and is maybe continuously refusing to have sexual intercourse with the partner. Willful is the word. Intentionally refusing to have any sexual intimacy. What do I mean? Mrs. A got married to Mrs. B at the marriage registry. It is on the eve of their marriage. On the night of their wedding, the woman was giving excuse that I'm tired, this and that, and then that day they were not able to do it. And since they were in the marriage, she's always having one reason or the other. That is a willful and continuous refusal for sexual intercourse is the ground. Then number two, we have adultery and intolerable acts. Adultery is just what it is. When when a spouse or a party of the married commits adultery, it's a ground for dissolution of marriage. You find your spouse cheating on you, you caught the person. It's not enough to say the person is cheating. You must have evidence to prove that indeed this person has cheated on you, or maybe there's a child from another person, that this person is the person's child. It's a proof that the person has committed adultery and you cannot reasonably live with the person. So the petitioner must prove that the marriage has broken down irretrievably with divorce. And then we also have unreasonable behavior under section 15 sub 2. It's listed there. What do you mean by unreasonable behavior? Maybe the respondent has unreasonably been making cohabitation unbearable, maybe by beating, domestic violence, sexual assault, criminal activities, emotional abuse, addiction, all manner of behaviors that you cannot even think that somebody can engage in, and the person is causing havoc in the marriage. That is unreasonable behavior. So you need to know that it's a ground that could evidence broken down irretrievably. And you also have dissertation. Dissertation, there are 3 types of dissertation under section 15 sub 2 of the Matrimonial Causes Act. We have one, which is a minimum of 1 year. Maybe the respondent left the petitioner for a continuous period of 1 year, at least 1 year. At least there's physical separation, there was no consent, no reasonable cause for that separation. The person just went on his own. You don't even know where the person is. So that could be a ground. And then the second one is 2 years with consent. That is, parties left apart for 2 years, though the respondent agreed to the divorce for 2 years, that I won't be around, I don't want this marriage again. And then after 2 years they come that, okay, come and go your own, I don't want to marry you again. So it is with consent. That is, we need the other party to be in court, the respondent to be in court, that this marriage cannot work. We have lived separately and I don't want to have anything to do with the person. So the third one is without consent. That's living apart for continuous period of 3 years. That is, party has lived apart for 3 years. Consent is not a requirement in this particular element under ground. So it depends. You may show up that you approach the court, I want to divorce and I don't want to have anything to do with this person. The party is not necessary. The respondent is not necessary in that particular ground, because after 3 years you can go your separate ways. And then the 7th one is failure to comply with conjugal restitution of conjugal rights. What do I mean by that? Maybe there was an issue, ab initio, and then you people went to court, and then the court settled you people, and then they said, okay, go and restore back your conjugal responsibility. And then the respondent disobeyed the court order or ignores the court order to return back to his spouse. So that is failure to comply with that, and it's also a ground. So the last one on my list for today is presumption of death under section 15 sub 2 of the Matrimonial Causes Act. Now, the spouse has been absent in circumstances that is reasonably led to the presumption of death. You have not seen this person for the past 7 years and above, and you cannot reach out. You have gone to family house, you have gone to all the friends, nobody saw the person, they don't know the person's whereabouts. This can be a ground for divorce, and it is called presumption of death. It is assumed that after you have not seen this person for at least 7 years, the person is presumed dead, and it can be a ground for dissolution of marriage. And it's also important that we remember that when we are proving dissolution of marriage, there are things that you need to understand, as I've explained to you at the issue, that you need to be sure that the wedding you celebrated is in a licensed place. That is, you wanted a statutory marriage and it is not court, but you went to church. And because that you went to church does not mean that the place is going to, so you have to be sure. So the jurisdiction for dissolution of marriage is the jurisdiction for dissolution of marriage is the High Court, the State High Court of the Federal High Court. And then so whenever you are going for divorce, there are certain things you need to also understand. You need to understand that the court will ask for compulsory conference, which is they will encourage it. mostly when there is children to the marriage or there is property. So this is because of welfare of the children and custody of the children, property, dissolution and settlement. So I hope with the little I have said so far, you have been able to gather information on things that can be of importance when you want to divorce in Nigeria. So if you have any question or comment, please try to indicate on our comment section in our social handle Lexy Talks on Instagram, TikTok, and YouTube. I hope that you have been able to take one or two things. So I'll see you on the next episode. Thank you and bye for now. I still remain your host, Alexlarry Filani. Bye.